Now, to continue the discussion on the reforms for the law enforcement officers' Bill of Rights, we do believe we have with us Attorney Vincent Agosta, who often represents law enforcement agencies during the LEOBoR proceedings. So, Mr. Agosta, if you're here, if you can proceed.
Good afternoon, Mr. Chairman and members of the Commission. I understand I have about 10 minutes to offer some perspectives on Bill of Rights. Is that correct?
Yes.
Okay, well, let me start by providing some background information. I have been in law practice for 41 years. I focus on labor and employment law and litigation and arbitration. I've been involved in LEOBoR investigation and prosecution when it was actually only 3 years old. So I've been around quite some time prosecuting fathers and sons, different generations, if you will, of police officers. And I've even had cases involving officers who went on to become police chiefs. So as Al Pacino said in the movie Scent of a Woman, I've been around, you know. And I hasten to add, so have my very worthy and highly regarded opposing counsel in this field, Joe Penza, and today you're going to hear from Michael Colucci. Very skilled and very vigorous advocates for defending the rights of police officers. Over the past couple of decades, Rhode Island surely has not experienced a shortage of police misconduct cases, most of which have resulted in criminal prosecution, employment discipline, or both, and of course, a great deal of media attention. These misconduct cases have come in all kinds of varieties. A police officer stealing cash from a single mother's shoebox in her home, pepper spraying, beating, and breaking the legs of a man who simply went through a stop sign, and then falsifying the arrest report to cover up the true facts of the incident. A female state trooper driving drunk southbound in the northbound lane on Main Street in East Greenwich, then fleeing the scene after a traffic stop by a local police officer, culminating in kicking, punching, scratching, and screaming, resisting arrest, and other acts of violence. Cheating on promotional exams and then lying about it, the so-called Providence Police Department testing scandal. Fighting in the street with a fellow police officer, first on horseback, then hand-to-hand, with uniformed combatants in full view of the public, resorting to weapons such as capstun, a baton, and oh yes, even a gun, all caught on video in downtown Providence. Brawling in the lunchroom of a police station that was instigated simply by one officer picking up another's bag of Chinese food to sniff its tempting aroma, teasingly. And that escalated into a melee, which eventually required the entire on-duty patrol officers to respond back to the station to quell a disturbance among their own. And that, by the way, ended with officers being disabled as a result of injuries and collecting benefits under our general laws 4519-1. And by the way, who among us could forget the infamous Peter Gilbert affair in the late 1980s? And more recently, the Cranston Police Department sex on duty cases. The infamous Ticketgate scandal, which set off litigation before, during, and in the midst of the LEOBoR prosecution, with trips to the Superior Court and to the Supreme Court. And just about a year or so ago, a recent case involving an unprovoked punching and an attack by a Pawtucket police officer off duty in a drunken state, I might add, triggered simply because there was a lack of warm water in the restroom sink, and he took his anger out on a rather diminutive 72-year-old man who was handing out towels. And there are a couple more in the hopper, which you've probably viewed in the news media recently. So I provide my background and my history in the investigation and prosecution of police disciplinary cases to orient you to my perspective. If you defend or you prosecute one of these cases, you will never be bored. And on a serious note, you will find that these cases, like any form of employment discipline and litigation, it's a whole lot like divorce, but even more like holy war. They are very, very intense cases. Now, time does not allow me to get into an exhaustive analysis of all of the intricacies of LEOBoR, but I hope to walk you through the House Bill 8036, for which I gave some input to Representative Williams. And I'd like to highlight maybe some of the mind traps and procedural complexities of LEOBoR and why I think the reforms that are set forth in House Bill 8036 will serve the public interest. And then we can open this up for some discussion, and I'm happy to entertain any questions. As you know, LEOBoR came into existence in '76, and it was modified on a couple of occasions in 1980, in 1982, and then more comprehensively in the 90s. And now here we are again looking at a way to balance the public interest and the important rights that police officers have. I suppose I should say that the advent of LEOBoR nationally, according to my research, stemmed from a perception that police officers' rights were not observed in the internal investigation process. Hence, they ought to have a procedural scheme to protect them against civilian complaints. But what has evolved are some very comprehensive statutory schemes around the country, which include rights that are far more expansive than the so-called Loudermill procedural due process rights that apply to all public employees. Essentially, in my view, what LEOBoR has done is it has supersized due process well beyond the realm of what the United States Supreme Court requires. And that begs the question that I would like the commissioners to consider. Why is this so? Particularly with public employees of law enforcement agencies, paramilitary agencies, individuals who may use force, even deadly force. Why is it easier to swiftly but fairly discipline a public works employee, for example, than a police officer? That, I think, is a compelling question for everybody to cogitate upon as you go through the process of considering reforms. Now, it may come as no surprise to you that Rhode Island's version of LEOBoR is considered to be among the most procedurally comprehensive in the nation. And that should become obvious to you as you go through some of the reforms that have been suggested by Representative Williams in House Bill 8036. So I'll just very quickly walk through a couple of these areas, and then I'll open it up to questions because I think that may be a more productive use of your time. One of the key issues in LEOBoR is the hearing committee composition. And I will speak to you with a great deal of candor because, as you know, this is a panel made up of two partial hearing committee representatives, one selected by the accused officer, one selected by the agency's head. And those partial hearing committee members serve as second advocates in the LEOBoR proceeding. They are not, as I think Mr. Vincent said wisely so at one of the last meetings that I happened to watch, these are not true neutral adjudicators. So the two partials, the wingmen, if you will, of the hearing committee, are serving the respective interests of the police chief and the accused officer. Then you have the so-called neutral adjudicator, and that neutral adjudicator is a police officer. And that police officer comes from one of two lists. One is a list submitted by the Rhode Island Police Chiefs Association, and one might actually think that an individual on that list would have in mind the best interest of management of the law enforcement agency and holding an officer accountable. The other selectee comes from a list made up of IBPO and FOP representatives. And those individuals obviously want to serve the interest of protecting the rights of the accused officer and potentially exonerating them. That is a very difficult scenario for a lawyer to present a case in, because you basically have a 50% chance to have a much better result depending on who that neutral is. So if you're prosecuting the case and the selectee comes from the police chief's list, you may fare better as opposed to that one coming from a labor organization. The process is fraught with conflicts. Let's not forget the fact that labor organizations represent the business interests of police officers. They are business associates. So it's very uncomfortable sometimes when I'm in a hearing and I can see an advocate on the other side, certainly not Mr. Colucci, but I have been in cases where the advocate sort of curries favor with some small talk about collective bargaining issues, the fact that everybody is bound together in the union brotherhood and sisterhood. So the panel needs to be changed. And the proposal to have 3 citizen selectees, I think, is a wise one. I think it brings balance, and I think we cannot underestimate the common sense and good judgment that the citizens of our state would bring in assessing misconduct. The other point I will get to, and again, there are so many complexities, I could talk for hours, but one other high point that I think this commission really needs to confront, and that is our police chiefs are essentially neutered and emasculated in Rhode Island in the sense that they may not impose discipline in cases that clearly warrant swift and decisive disciplinary measures. That is because under LEOBoR, any measure that is considered punitive, such as a suspension or ultimately a discharge, may only be recommended. So in essence, a chief recommends what should be done, and then it has to be vetted by a trial-like process which has all of the attributes of a civil trial or even a criminal trial. And a prosecutor friend of mine once remarked to me that trying a Bill of Rights case seems to be more intense and in many ways as complicated, if not more, than trying a murder case. And that's a logical assessment to make because after all, someone's career is at stake. So I do think that the commission ought to look at the roadblock that exists for police chiefs to upfront discipline. What's proposed in House Bill 8036 is to allow for the immediate imposition of discipline and then invoke the LEOBoR process to appeal that. And I think that is more consistent with the manner in which other public employees are disciplined. And I think that serves the public interest while at the same time affording the due process minimally that any employee would get before a suspension or a deprivation of a property right. And the last thing I'd like to say about the House bill, which I think is critical, is it changes the authority of the hearing committee. The hearing committee under House Bill 8036 would be limited in its review, and in this sense, it would not be able to overturn or second guess the decision on discipline of the hearing of the chief of police or the head of the agency. And it embodies the doctrine of deference. For those of you who aren't familiar with that doctrine, it's commonly known in labor and employment law, where if evidence is established to prove that discipline is warranted, then the arbitrator should defer to the judgment of the employer. And the logic of that, Commissioners, is that when all is said and done, after the LEOBoR case is over, it's the chief of police that has to live with the consequence of the discipline. And so the hearing committee ought to give great deference, in fact, full deference, to the judgment of the management of the police department, typically the chief of police, in what measure of discipline is appropriate. And it should not be overturned unless it's completely arbitrary or completely capricious. So given the time constraints that I have, I'll stop and I'll entertain any questions. I have many more comments about LEOBoR, but again, given the time constraints, it's probably best I entertain some of your questions.